start with the actual cross-examination. I want to be brief and direct. Please listen to the questions. I'll answer my question. You understand?
I understand, and I'll answer it to the best of my ability.
Yeah.
So if I have to expand, and you must just agree that I must be allowed to expand as well.
I will monitor it. What I'm saying is just listen
Yes.
to the question. Now, I want to put this proposition to you as a former police officer and authorized officer at ACC. You have considered that there are a number of ways to secure attendance of an accused person to court. Number of ways, not arrest you. At the beginning of my cross-examination, we dealt with that. You
That's
remember?
right.
And when you say to secure attendance, do you agree with me? It's primarily for purposes of the trial.
Of course.
But of course, if the consideration of justice dictates, it is only then a person can be prematurely be brought to court when the trial date is not within a short period of time. Do I need to repeat?
I hear you, but I don't agree with you.
Okay? So you understand the
Because the moment you secure the attendance of the accused person, it means, that legal representation comes in, investigations has to be concluded and so forth and so on. So there's a number of factors. But ultimately, is to ensure that the person, stands trial.
You don't understand. It's very clear. Look, people can come to a criminal court for purposes of a trial. Is that correct?
Not entirely correct.
For
You
what?
are not going to secure the attendance of the accused person directly for trial.
Listen, the end object is for a person to stand trial.
And that's what I said.
Okay, fine. But it's only if there are grounds to arrest, to bring a person to court prematurely, when you are not ready, can you arrest the person to come to court? Do you agree with me?
I don't think I'm hearing your question.
I can repeat.
Please do.
If the end object of getting a person accused to come to court, the ratio behind it, it's a trial, and I mean a trial, then it must follow that in cases like in this case, where you are not ready for trial, it's premature, there must be a reason that triggered a premature summoning or arresting of the person to come to court before the trial date is set, the indictment is not there, the charges are half cooked, whatever. There must be a reason for you to prematurely. It's not just a nice thing to have.
I don't agree with your statement, Mr. Namanje.
Okay.
A lot of work has been put in terms of the investigations and the evidence that has been gathered.
Okay.
So for you to say that the trial date should be, just closed, that is not accurate.
Okay, fine. So otherwise, then it must follow your logic is this. If there is good evidence, even if you're not done, if you want, you can just arrest. The next day you ask for a postponement for further investigation. Is that the way you work?
Your Worship, investigations has been conducted for at least over 12 months. A lot of evidence has been gathered, evidence which proves that there were offenses that were committed.
Okay.
In this regard, the accused persons were brought to court.
But the state is not ready to have them bring on trial. The state is not ready.
Your Worship, Mr. Namanje earlier asked me if I was talking on behalf of the state. And I think since he started with the cross-examination, he's been asking me to talk on the state and on the state. But as far as the investigations is concerned, Mr. Namanje, a lot of work has been put.
Your Worship, can the witness please divert it to answer the question? The witness did not answer. And I do not really appreciate the witness trying to argue. The witness didn't answer the question. Your case that you are investigating is not ready for trial.
It's still under investigations, but the investigations are at an advanced stage.
Yes, that's what I'm saying. But you arrested accused persons on the 8th of July when you do not even know when the trial will start because your investigation is not complete.
Your Worship, is not in my position to know, and I'll not be able to tell as to when the trial would be because there's a number of factors that has to take place or to come in play before the trial happens.
Okay, but you did not cause my client to be arrested in January. You waited for July. Is that correct?
I don't understand what you are implying.
Yeah.
Because I know they were arrested in July.
Okay, let me make it clear. So it's a matter of choice when you want to do it. It's not dictated by the need to bring them to trial. It's just that because you have the power, you can exercise them anyway. You could have delayed it for 3 days. Nothing would have happened to the administration of justice. That's what I'm trying to say. You have this massive power. There is no trigger event. You just wanted your hands to be laid over my clients and bring them to court, even when you have this wrong and bad charges. That's what I'm trying to say. It's not triggered by a particular...
Yes, counsel, can you just make your questions short so that he can answer?
Okay.
Yes, it's not triggered by any if.
That is not accurate, Your Worship.
Okay.
There is a process that is being followed. Investigations was ensured, evidence was collected. By January, the month that you are referring to, maybe by that time the investigation was not at the level where it is currently is.
Okay. But tell us, what triggered in July that the accused person indiscriminately must be arrested? What triggered? Why could you not, for instance, wait until today? What triggered the arrest?
But Your Worship, he will still ask me the same question why I arrest them today. I said already, evidence was collected, evidence was gathered.
Okay. Should I record it? Your answer, the trigger event, the evidence was collected.
What I said earlier is, the investigations are at advanced stage, and therefore the accused person's attendance was secured so that they can be brought to court, Your Worship. We finalized the few outstanding issues here and there.
Okay, so you were monitoring. If you have evidence up to this level, you would just then exercise your power to arrest. That's a trigger event. You were waiting for evidence to reach a certain stage. You are not ready for trial. Investigation is not complete. Then you arrest.
Your Worship, you cannot arrest a person on an investigation of this magnitude when you have one statement, because you will be shooting yourself in the foot in terms of the work. We needed to make sure that the level of work that has been put in place at least justify and proves that there are offenses that were committed.
Okay. I don't know whether you get it. Your answers are actually dangerous to your case, but I will ask in relation to another aspect. So, fine, you say you collected evidence, you cannot arrest it in one statement. You waited until you have how many statements?
Your Worship, this is a significant investigation. I would not be able to tell the court how many statements we have.
Okay.
But I know when the prosecution was dealing with the charges, they had to go through over 20 volumes And in total, Your Worship, we have at least over 40 volumes of evidence that we have gathered.
No, it's fine. Please remember that people cannot be arrested on arbitrary basis. Your action must be rational. You understand? Do you know that?
Of course.
The arrest must be necessary. Do you know that?
Of course.
Okay. Let's go over in respect of another aspect. You cannot name. Initially, you say to us what you cannot arrest on one statement. Now you cannot say how many statements. But was it you who took a decision that they must be arrested? Was it you?
Your Worship, I don't see the relevance of this question, because I work for the Anti-Corruption Commission. When a decision is made by the Commission, not by me. I'm the investigating officer. It means we have processes in place that we put in place as to how investigations are conducted.
Oh. You didn't want to answer the question because it's not relevant, but you ended up disclosing that it's not you who decided that people must be arrested, including my client. Do I get you correct?
No.
So what is the note to that I didn't get you correctly, or not what?
You didn't get me correctly.
Okay, what is your answer?
What I was explaining from the beginning is we investigate. Once we get to a certain point, to a certain point, and have proven that there is sufficient evidence in these regards. That is why the accused persons were secured to come to court, because there is, and as a commission, we believe the evidence that we have gathered, it's good. And yes.
Do you have a rigid policy that if you have a good evidence, you arrest before you transfer to the PG in terms of Section 31? Do you have a rigid policy that if the evidence is good, arrest? Do you have such a policy?
Your Worship, transferring a case to the PG can be done before or after an arrest. It just depends on a particular investigations.
Answer the question, sir. Do you have a rigid policy? If you have good evidence, you must arrest. Answer the question.
No.
Okay. So in some cases, you can have good cases, but you don't arrest until the PG decides. Is that correct? In some cases, you can have good evidence, you don't arrest until the state is ready with an indictment in its hands. Investigation is concluded, indictment is there, everybody ready for trial.
Each case, Your Worship, is dealt on its own merits, and it's also dependent on the seriousness of the case that is being investigated and the complexities that are involved. Your Worship, also taking into consideration of interference with investigations and so forth and so on.
Yes,
so there's a number of factors that are taken into consideration.
But in this matter, I have been asking you, your reason was not a fear of interference by my client. I have been asking you. Now, why are you talking about interference in general?
Your client is not the only person that is before the court.
Okay, fine. Okay. So, but let me make it clear. So, can I record it for purposes of my argument then? The sole reason why on the 8th, my clients of July were arrested is because a stage has been reached where you have what you call a good case. That is the sole basis.
Your Worship,
based on what you told the court.
An arrest is part of investigation processes.
Okay. It's shocking. Okay, now let me take it further. But did you consider how illogical your approach is? In that the next day, the first day of appearance, the public prosecutor, at your request, asked that the state is not ready for trial, the matter must be postponed for further investigation.
And Your Worship, I have said it before that the matter is still under investigations. There was no point when I said investigations is completed or
Yeah,
are
no.
completed.
I never said that. All I'm showing how illogic your policy or your action. You go and collect people from their houses. There is no trigger event relating to interference or running away. It's just a good case. You, without exercising a discretion, you arrest. You fill up the court roll. That's why you people are under pressure, unnecessarily.
I'm not sure I can comment on that one, Mr. Namanje,
You don't want to comment, it's fine.
because there's no way that it was illogical, the decision that we took. We took a logical decision, a decision that was informed by the amount of evidence that the commission has gathered.
But you made a fatal statement that will work against your case. You are not the one who decided to arrest. You said that. Who was that?
I said,
Name the person.
I said the commission.
No. Commission does not speak. Say the person. Commission, if it is the Director General, you must say. If it is the Deputy Director General, you must say. If it is the Chief of Investigation and Prosecution, you must say.
No, Mr. Namanje, I don't have an answer for you. All I'm saying is investigations was at an advanced stage and a decision was made because of a number of other factors.
But then it is very clear, if that person, unknown person, didn't arrest my client, you wouldn't have arrested because it's not your decision.
I'm not sure of the unknown person that you are talking about.
We won't know because you don't want to disclose the person.
No, Mr. Namanje, investigations have been conducted. It has reached an advanced stage, and at that point in time, a decision has been made in order for us to make sure that all the other outstanding issues are finalized.
Do you know, I think you appear to, do you know that this is a country of the rule of law?
I'm very much aware of
But
that.
only exercise the power that you have, don't exercise the powers you do not have. Do you know about that?
I'm very much aware of that.
Do you also know that you can only arrest a person if you yourself, the mental part of it, is satisfied that there is reasonable suspicion, the arrest is necessary, so someone must account for the arrest.
And I'm standing here.
But
I'm the investigating officer.
you didn't take the decision.
No, Mr. Ramanje.
What is now, no, Mr.
When I'm saying the investigations has reached an advanced stage, it means it has. And one of the investigation process is to secure the attendance of the accused persons to court. And that's what we have done. As far as exercising our powers, we made sure we exercised our powers within the rights. We exercised our work within the rights that we are also given.
Say, why is it difficult to tell the truth? What I'm saying, I thought you said earlier you did not make a decision. Now you are saying, no, Mr. Namanje.
When I stand here,
Yes.
I represent the commission.
Yes.
So, and when I'm saying we have a process within the commission that is followed,
Yes.
so it means I'll stand by for it.
Okay, let me ask you a question. Is there shame to disclose transparently who made the decision to arrest? Is there any shame?
If you have a name of somebody that you think has made that decision, Mr. Namanje, maybe you can help me.
Your worship, can get the witness directed to.
Yes, sir, just answer, but the question Mr. Namanje has been asked. The witness is saying the commission made the decision. You want an answer, but he is saying the commission made the decision
Your worship,
and he is
I
not.
asked a different question altogether.
Your Worship, I have to object because I think for the past 5 minutes the question has been asked and answered just a bit different. He wants a name and he has said the commission took a decision. The commission, not him. So I don't know if he wants a name, but he has answered. He has said that the commission took a decision.
With greatest, Your worship, what the last question was, is there shame in disclosing? I'm now asking the ratio, the reason for not disclosing. I'm no more asking the name. The witness must answer the question, Your Worship. It's a country of, I mean, an arresting officer is the first time in my brief but active and
Mr.
busy.
Namanje, you have put your question. Just brief question. Say, is a shame. What is your comment?
There is no shame, Your Worship, and I've answered it already. And I said I am here, and I represent the commission.
But you are contradicting. When you say you are here, but you are not the person who took the decision. You continue saying, when I ask another question, you say, I'm here. What does that mean?
Mr. Ramanje, I believe I've answered your question.
No, listen to me. Fine, I have asked about shame. Is it privileged to disclose who is an arresting or a person who took a decision?
You know, when I said the commission, it means there are different levels of structures.
Yeah.
And when a case is being investigated, it goes through these different levels of structures.
Yeah.
And hence I said, at a point, once we have reached a certain point in the investigations,
yeah,
then a decision is made for us to secure the attendance of the accused persons to court.
Yeah, that's what, it's fine. I'm asking this question for two reasons. One is on your credibility as a witness. One, in respect of an issue, the issue of necessity of arrest. Because you cannot account for it because you are not the decision maker.
Mr. Namanje, I have been in charge of the investigations,
Okay.
and I've indicated that investigations are at advanced stages, and at that point, a decision was made to arrest.
Okay. You did not arrest my client because you had information that, like two clients, they wanted to run away. That's not the reason. That's not the reason. Whoever decided.
A number of factors contributed to that.
No.
But I did mention that we reached a certain point where we had overwhelming evidence, as I indicated in the examination in chief.
Your Worship, honestly, we cannot. If my clients were also asked by court and directed to answer simply, can this witness just stick to the questions I'm asking? Continue going back to the, I will reach the certain stage. I want to be specific, Your Worship. The witness must just answer questions.
Sorry, what is your answer?
Your Worship, is because the same question is being asked just in a different way.
The witness is protesting against court. Can the court direct the witness, please?
So what is your answer? Are you saying you have answered the question, or what are you saying?
I believe I've answered the question. Maybe he can rephrase the question, Your Worship.
Yeah, just be serious. We are not playing here, sir. Look, I'm putting it to you. You did not arrest my two clients because you have information they wanted to run away from Namibia. I'm putting it to you.
No.
Okay? I'm putting it to you. You did not arrest my client because you had information that they will interfere with investigation.
No.
Say you did not arrest my client because they will be danger to the society if not arrested until you complete your investigation.
No, Your Worship.
Now I wonder why. Okay, let's go to another issue. Do you know that, I will assist you. Do you know that even when you have a warrant of arrest, you have a discretion not to arrest? Do you know that? Have you ever read judgment saying that?
Yes, the discretion is there.
That even if you have a warrant of arrest from a magistrate, you can still exercise the discretion not to arrest because it's not necessary.
That's correct.
Okay. Do you know the requirement both in the Criminal Procedure Act and in the Constitution that a person being arrested must be promptly and fully informed of the grounds of his arrest? You know that?
That's right.
In relation to this matter, did you comply with such obligations at the time of arrest?
Most definitely.
Okay. So, I understand you that in relation to the grounds of arrest appearing in the purported warrant, you fully and promptly informed my client.
That's correct.
Do you agree with me that if you do not understand the elements of a particular offense, then there is no way you would have fully and promptly informed a suspect? If you don't understand as a police officer or a member of ACC, you don't understand the elements of the offense, it will be difficult, in fact, impossible for you to explain meaningfully to an accused person.
When a person doesn't understand the charges, that might be the case, Your Worship. But in this regards, we made sure that the charges which were on the warrants, we understand the elements of those charges.
Okay, no. I want to take you to the charge and demonstrate that, in fact, you don't understand, Mr. Imamba.
Sure.
Okay. Now, and that is what I'm going to do.
Maybe before you proceed, it's opportune time for the court to take a line.
That's the code.
The court adjourns until 1400.
Authorized.